The coming and going rule. This is a great rule that everybody typically misinterprets and gets wrong most of the time. Not the judges, not the appeal board. Sometimes employers will hear about this rule and they'll say, "Oh, yeah, that coming and going rule. They're injured when they're injured in the coming and going to work. They're covered, right?" No, it's just the exact opposite of that. But anyway, we'll get into that. This is an decision November the 5th, 2015, issued by the Commonwealth Court. Keep in mind, it's a not reported decision or opinion, meaning it's persuasive, but it's not binding on anybody. So the Commonwealth Court issues a lot of decisions where they don't report them. They still issue them, and they're up on Google. You could find it on Google Scholar without any problem. You could read them, and I think they are persuasive. You can get a good idea about how the Commonwealth Court is looking at issues. But in any event, facts of this case pretty straightforward. I always find it amazing. Claimant in this case was injured. What I find amazing is disputable, but the claimant in this case was injured February 2008. Keep in mind that. The decision is November 2015. I'm doing this recording in February of 2016, 8 years after this poor individual. Maybe he's not poor, I don't know. Maybe this guy is rich, who knows, but 8 years after this guy was injured, this decision is rendered. So what happens? So this guy works as a driller for this, of course, appropriately so, for McKinney Drilling Company. And he's insured, McKinney is insured by Zurich, American good insurance company. Their claims adjusters are well trained. They know what they're doing. Injured, basically the facts, I'll try to summarize them the best that I can here. This guy's a driller, of course. He is working at a field location in Virginia. The home office is in Pennsylvania. He doesn't go there a lot. He does go there to get his assignments or if he has to drop off tools or whatever. But anyway, he's working in Virginia as a driller. The employer would pay for his gas back and forth. They would pay for his hotel. They give him a stipend for per diems. And he stays for the week down in Virginia, does his work, and then comes home on the weekend. So, of course, he's coming home on a Friday night after he worked the entire work week in Virginia, gets a flat tire, it's snowing, he climbs up into the back of his personal pickup truck, slips and falls out, hits his head, injures his neck, head, lower back. Reports it the next day. He was able to fortunately drive to the Uniontown Hospital, doesn't remember a lot about the accident itself himself. Is treated, and then, here's the amazing thing I see in this case. October 2010, he files the claim petition. It's a 2008 injury. He files October 2010, which tells me that he probably had some type of disability insurance. Maybe he had unemployment compensation coverage. Maybe he had first-party coverage for the auto accident. He's injured. I don't know how that worked out, but somehow he survives for more than 2 years and files a claim petition, goes in front of a judge. Evidence is put on. Basically, the claimant testifies, like I said. Employer testifies a little differently and said that it was a fixed location, that he was there, and he really wasn't a traveling employee because it was a fixed work site that he was at. So basically that's the facts. I don't want to get into too much. It'll really get bogged down, but that's the overall argument here on terms of what happened. So what happens now? Employer raises coming and going rule. Your Honor, he was injured on his way back from work. He was not on the clock. He was not in the course and scope of his employment. Therefore, this is not a covered injury. I would make that argument too. Tough argument to make because just the underlying facts. Home office is in Pennsylvania. He would travel there sometimes, injured in Virginia, and they couldn't really overcome the fact that this guy was injured, or was rather required to work in different parts of the United States, northeastern United States, in the course of his career. This was not a job that was going to last forever. It was a temporary job, and then he would have been assigned somewhere else. But anyway, they make the argument. The judge finds, nope, coming and going rule. There's an exception to the coming and going rule. So let's talk about that, because that's important. A lot of people sort of reverse the coming and going rule sometimes. I don't know why people do that. You have to start with every case that the claimant must be injured in the course and scope of their employment. That's very important. So in order for the claimant to be injured in the course and scope of their employment, they have to be furthering the interests of the employer's business at the time they are injured. If they're injured going to work or coming from work, that's not in the course of their employment. All right, they're not doing their job at the time of the injury. They're just driving to or coming home from work. So you start there. So that's the coming and going rule. It actually says you're not covered if you're coming or going to work. You're not covered by the Workers' Comp Act. However, there's 4 exceptions. All right, cases you want to know are Biddle and Setley. Those are the big cases. So start with the proposition you're not covered if you're going to work or coming home from work. All right, except you have a contract that includes transportation to and from work. The claimant has no fixed place of work. The claimant is on a special mission for the employer, or there's other special circumstances such that the claimant was furthering the business of the employer. All right? Claimant's employment contract includes transportation. That's if they drive you to and from work. Sometimes you see that. I see that a lot in the Poconos with some of the hotel resorts. They will provide transportation for the employees from their house, usually in a residential housing place. From the house, they'll give them a bus ride to the employer's hotel or resort. If they were injured on the job there, they would be covered. If they were injured, rather, on their way to or from work on a bus owned by the employer, and that's part of their contract, they would be covered by workers' comp. Claimant has no fixed place of work. You know, you're a traveling driller or you're a traveling excavator. You go from site to site. Welders, you see this sometimes. Welders will go from site to site. They are not excluded by the coming and going rule because they have no fixed place of work. They're always going to be moving around. So chances are they're going to be injured on the way to a job site or coming home from a job site. They're going to be covered by workers' comp and get paid benefits. Claimant is on a special mission. Good example of this. Hey, Lucy, would you take the mail over to the post office on your way home from work tonight? She's injured on the way to the post office. Chances are she's going to be covered by the Workers' Comp Act. It is not an exception that she's, in other words, the coming and going rule doesn't block her from collecting benefits. And if you think about it, when you're on a special mission from your employer on the way home from work or coming into work, you're in the course and scope of employment. You're doing something you normally wouldn't do otherwise. So it's really one and the same. Or special circumstances, sort of a catch-all provision where the claimant is furthering the business interests of the employer. So what happens in this case? The employer makes a pretty good argument, I think, that this guy really did have a fixed place of employment because the site he was at was going to last for a month or so. That location, that job was going to be a long-standing job. Therefore, he was able to stay there, and he's not really, when he leaves that job site and it's over, he's not really a traveling employee. Decent argument to make. I'm not sure if I would have made it, but now, especially in light of this decision, you know, hindsight's 20/20, and we can Monday morning quarterback these decisions all the time. But in this particular case, the judge didn't see it that way. The judge said, listen, you know, he was a traveling employee. This was a temporary job. He was going to be assigned somewhere else when this job was done. He's injured on his way home from this job. Therefore, he's not, you know, excluded by the coming and going rule. Appeal Board affirms. They cite some cases that are factually a little different. They say, you know, last paragraph's always really where you want to look. In these Commonwealth Court decisions, they sum it up nicely here. There was substantial evidence to support the judge's determination that the claimant was a traveling employee. Claimant's employment took him to temporary placements throughout the Northeast region. The Virginia project was not indefinite because it was scheduled to last for only 35 or 40 working days. Claimant could have been assigned to another project even before the Virginia project was completed. So his employer could move him around. He was reimbursed for the gas that he was used to travel to and from the work site, and the employer paid for his lodging near the work site. All these factors add up to the fact that coming and going rule does not block this individual from collecting benefits. I don't see any job offers here made by the employer while this case is pending. It's certainly interesting to me how much time elapsed between the date of the injury and the date he files a claim petition. I wonder if it was denied early on. I would certainly, even if there was a denial, I would want to know, if I'm representing this employer, what's the claimant doing? I don't see anything in here about an unemployment compensation benefit offset. Hopefully that was something that this guy collected for 6 months or so, 27 weeks. They distinguish the cases that the employer cited in the footnotes here. And once again, you always want to look at the footnotes too. That's where they really get down to some of the more technical aspects of the case. But I think in this case, the court made the right decision. Of course, like I said, hindsight's 20/20, and we could Monday morning quarterback this case because we see it. But when you're in the heat of the battle, I could certainly see making this argument that this gentleman did have a fixed place of employment, although 35 to 40 days seems a little light. If it was longer, 6 months or a year, I would certainly make the argument. But on the other hand, too, I'd be offering this guy light duty work to try to cap that amount of benefits that are back due to him. In any event, good decision. It could probably be appealed. So if you see any issues in your cases in the future, of course, you're listening to this. I'm recording this in February of 2016. So case law could change. Boy, the way the Commonwealth Court has been writing decisions lately, they could totally get rid of the coming and going rule. Who knows? In any event, thanks for watching.